For those of you who just joined, I'm Sue Ostoff. I'm with the National Clearinghouse for the Defense of Battered Women, and thank you for joining us today. Before I go further, I just want to briefly thank the Office on Violence Against Women for the support of this webinar and for the support of so much important work on behalf of victims of battering charged with crimes. And as you're probably aware, today's webinar is titled, How to Prepare a Client for Parole. And this is, as you probably know, the second in a two-part series about parole by these two speakers. And it's fine if you didn't participate in the first one. You can go back to it if you wish, but it's fine that you're here. The first one, What You Need to Know About Parole, was held on October 18th. And if you want a recording of the webinar and the supporting materials emailed to you, you can write to DOT as well. And we'll also are in the process, after this one is done, we'll post both webinars on our website in probably a few days. So in an effort to save time, I'm really going to do an extraordinarily short introduction of our two speakers today. I know this is really small print. It is for my old eyes anyway. And if you want to see it in a bigger font, you can get that from the Google Drive. We put a copy of their bios there. I mean, I have to say, this has just been a real pleasure and a real honor to learn from these two amazing women. And I really appreciate the important work that they've been doing and are continuing to do. And I did a more in-depth introduction on the last webinar. And I know many of you already heard that, or you can go back and listen to it if you wish. So given that reality, I'm going to really just let you read their bios, and we're going to move over to them in just a minute. I just want to say, if you have any questions, you can type them in the chat box in the lower left-hand corner. I'll be collecting them for our presenters. And Leigh and Lila plan to leave about 15 minutes at the end for questions. So I just want to say how pleased we are to have Leigh Goodmark and Lila Meadows with us again today. And thank you so much, Leigh and Lila, for all your great work, and thank you so much for your willingness to share it with all of us today. So I'm going to turn it over to you guys now. So thank you.
Thanks so much, Sue. So this is Leigh Goodmark, and I am a professor at the University of Maryland, Carey School of Law, and you had mostly Lila last time, and you get mostly me this time. And there may be a little bit of overlap from last time, and I apologize for that, but hopefully the integration of a little bit of last time and most of this time will give you a good sense of what we're talking about in terms of preparing a client for parole. And just to give you a sense of how we came to this work, as I said last time, I got the opportunity 4 years ago to start a new law school clinic at the University of Maryland and really wanted to think about all of the ways in which people subjected to abuse and violence are underserved, and had the opportunity to work with Second Chance for Women, which is an advocacy organization on behalf of women seeking parole in Maryland, and began taking cases from them. It's been an absolutely amazing experience for me and for my students, and I hope for our clients as well. The work is unbelievably rewarding, really thought-provoking, and incredibly important. This is a community of people who is so vastly underserved. And because you don't necessarily have to be a lawyer to do this work, it's really great that so many of you are advocates and other folks who ordinarily may not be able to speak in court or do other things in the kind of courtroom context, but could make a huge difference in terms of clients seeking parole. So all of that being said, let's go ahead and dive on in. So last time we alluded a number of times to something called a parole packet, and that's really what I'm going to spend most of our time talking about today. When my students become involved with a case, ordinarily the client has either been up for parole once unsuccessfully or hasn't been up for parole yet, and the materials that they've provided to the parole board aren't terribly developed. They may have put together a letter of remorse, which I'll talk about in a little bit, or some certificates and other documents from programs that they've done. But the parole packet is something more than that. a parole packet is really a collection of narratives and documents and all kinds of information that gives the parole board a sense of who your client is now, as opposed to when they committed the crime, and why it is that your client is a good candidate for parole. And so in the Google Drive, we've provided you with some examples, and I'm going to refer to those throughout the talk today. And what we've given you are three big components of the packets, which I'll talk about in about 2 slides. Not included some of the other things like all of the documentation that our clients amass. But that packet is really the primary source of advocacy on behalf of our clients, at least in Maryland. It's our single greatest chance to give the commissioners who are deciding our clients' fates a sense of who our clients are as people, what they've been able to accomplish since coming into incarceration, how they've changed, how they perceive their change, whether they have community support or not, how thoughtful they've been about their life post-incarceration. It really fills in the picture of who the client is, and for that reason, it's incredibly important. Sending a client up with an incomplete or ineffective packet is something that I just think is a tragedy for so many of the clients, because it really is the only way that the Parole Commission is going to get a chance to know them. The other piece for us is, because in Maryland our clients are not entitled to representation during parole hearings, it's the place where we can be advocates. We can't go into the hearing and do that kind of advocacy on behalf of our clients. So this is our real advocacy piece on behalf of our clients. So why does the packet matter? Well, I've told you a little bit about that already, but just to back up a piece. Generally, without a packet, if you look into a client's parole file, it is full of stuff that's been developed by the state in one way or another. It comes from correctional sources, a pre-sentence investigation, an infraction history, treatment records from treatment they may have received while they were incarcerated, other kinds of institutional memoranda. And it probably includes, in many cases, some kind of victim impact statement or letter from the affected people talking about why your client shouldn't be paroled. And that's all that the Parole Commission would know without the presence of that packet. They would only have the state's or the victim side of the story, but they wouldn't have anything to fill in all of the things that your client may have done and achieved since the time that the client has been incarcerated. They also wouldn't have any sense of your client as a person. And so the parole packet gives you a chance to humanize your client for the Parole Commission, to talk about the things that the Parole Commission is unlikely to ask about unless they're prompted to do so, to give them a sense of who this person is in their religious life, in their work life, in their family life, and all of the facets of people's lives that make them much more human. And also, depending upon the interactions that the client has had with correctional officials, you may be supplementing the already kind of positive assessments that your client has gotten or enhancing those assessments, but you may also be trying to balance out a story that the correctional officials may be telling about your client. If you don't tell the Parole Commission about these things, no one will. So it's important that we are out there saying, you know, this is what our client has achieved. This is the support that our client has in the community. This is our client's reentry plan. If we don't do it, no one will. And again, that advocacy piece is really important. The stuff that is in the parole file that comes out of corrections is, in theory, objective. It's just kind of the facts of who this person is and what they've done. But we have the opportunity to write persuasive narratives about who our clients are, to give some context and some color to the things that they've experienced, and to really address some of the weaknesses that may be in the case. And so our job is not to be objective. Our job is to be persuasive, and we are the only people who are going to be doing that work. And the packet allows us to do that, especially, again, in places where we can't do it within a hearing setting or other kinds of advocacy settings. So this packet's pretty important. And what should it include? Andrea Bible said something in a phone call a couple of weeks ago, and Andrea's done way more of this work than I have, that I really loved, and I wanted to give you this piece of wisdom that she shared with us, which was a parole packet should really be about three things: about responsibility, about remorse, and about rehabilitation, so that your client has taken responsibility for their actions, that they have expressed remorse, and that they have experienced rehabilitation. And we can do that through all of these tools that you see on the slide, and I'm going to talk about each one in turn just a little bit. So we start our work with the client's narrative. It's really a life story, and that life story is not meant to excuse the client's behavior in any way, but it's meant to do a couple of other things. It's meant to provide balance against anything that may be in the institutional file. It's meant to provide a context for understanding the client, for understanding her life and her experiences, both pre and post incarceration. And it's meant to give her a strong voice. So we almost always do our life stories in the first person because we really want the client to get the opportunity to talk to the commission about what they've experienced. Some clients can't do it. They find it very difficult. One trick that we've used is to write them in the third person and then change all of the third person pronouns to first person pronouns so that the client doesn't have to do it in the first person, but we can provide that voice nonetheless. The narrative for us often starts from the childhood. It just gives a fuller picture of who the person is and allows our parole commission to appreciate some of the obstacles that our clients may have experienced, some of the history that made them who they are, and goes through the present so that we can talk about all of the ways in which our clients have changed. The legal memorandum is the most lawyery kind of thing in the packet, and it's organized around the factors that the parole commission is going to consider. And different legal memorandums look differently, so they're tailored to the client's particular circumstances. So in the legal memorandums that we gave you, you'll see that for client one, we stressed education and employment and family and personal growth, all of which are factors that the parole commission is going to consider when they make a determination as to whether this person is a good risk to go out into the community. So we talked about how this person had derived a bunch of educational credits while they were incarcerated and what they might do with those in the context of employment, and the strong family structure that the client was going back into upon release, and the personal growth that the client had experienced as a result of the different programs and opportunities that she had had while incarcerated. In Client 2's narrative, you'll see that we stressed whether her release was compatible with the welfare of society, the low risk of recidivism that she posed given her age, and given the fact that because her crime was a crime against her intimate partner, it was unlikely to happen again. Again, we talked about her employment. For that client, we talked a lot about her mental health treatment, and in several minutes, we'll talk more about mental health issues in the parole packet. But it's important that we tell the parole commission this person is not a risk to release, even though they have significant mental health issues, and here's why. And finally, we stressed the change in her as a result of the work that she did on herself while she's been incarcerated, and also the changing norms about intimate partner violence. So one of the things that we're able to do in that legal memorandum is give a wider societal context for the work that we're doing as well, to say, 17 years ago when this person was convicted of murder, people thought about intimate partner violence in this way, and possibly a judge or a jury wasn't looking at these issues in the same way that a judge or a jury might be looking at them now. And because of that, the parole commission should take into account the ways in which we now understand things like imminence, and whether someone is feeling an imminent threat, or why people don't leave, which is a topic I'm going to come back to several times over the course of this webinar today. So we include social science research. We include other kinds of persuasive authority to bolster our point that this person is a good risk for parole based on the parole factors as outlined by the state. In the client's letter of remorse, it's really the client taking responsibility for their actions. And that looks very different depending on the client. So we're going to talk about that a little bit more in a couple of slides. But suffice it to say for now, and as Lila said last time, different people are in different places when it comes to remorse. And even though they might be in the parole process, they might not yet be ready to take full responsibility for what they've done, for lots of different reasons, and again, talk about that in a second. The two that we've given you from Client 1 and Client 2 are from people who've really taken responsibility for their crimes without reservation, who are able to say, I know what I did, I am unbelievably sorry for what I did, there is not a day that goes by that I don't think about this person and think about the pain that I've caused to others as a result of my actions. And those are wonderful letters of remorse, and if you have clients who can write letters of remorse like that, that is a fantastic thing, but they're not all that easy. And like I said, we'll go back to that in just a moment, but those of you who were here last time, you know that Lila talked about that a little bit as well. Documentation of the client's achievements. So one of the things that I think always surprises my students is just how much our clients are doing while they're incarcerated. Many of them are engaged in post-secondary education or other forms of training. Many of them are working, often in jobs that they did not have access to while they were living outside of the prison system. They are starting organizations. They are engaged with religious communities. They are working on community projects. They do Girl Scouts, and they do book clubs, and they do all manner of things where they're interacting with folks. Many of them are speakers who talk to tours who come into the prison. So their achievements are actually quite impressive. And we document those so that the Parole Commission will have a sense that this is the kind of person who is bettering themselves through education, is able to work and will work hard and has a marketable skill, and is going to give back to the community. So our clients, particularly those with long sentences, frequently have very thick packets of these certificates and other forms of documentation. This also can include commendations from correctional staff. And it's interesting, our rules have recently changed in Maryland. Correctional staff can no longer write letters of recommendation on behalf of clients who are seeking parole. But you may have those kinds of commendations through work, evaluations, or through other kinds of programmatic activities within the prison. Reentry plan. So it's not enough for the Parole Commission to believe that someone is a good candidate for release. They want to have some idea of where your client is going and what they're going to do once they are out into the world. And so, you know, there are lots of options there. Many clients, the one thing they want more than anything else is to get back to their families, and they want to be in that space. Others are more thoughtful about the difficulties that they might face in going back into a family setting or in adjusting to life outside of the prison system. Most of our clients are serving very long sentences, and many of them, as Lila told you last time, don't get paroled the first time that they try. So we may be talking about people who've not been living outside of the prison system for 10 or 15 or 20 years, and that adjustment period is very difficult. The Parole Commission worries about that adjustment period, and they want to be sure that people are going to be able to settle in and not have re-involvement with the criminal justice system. So part of our job is to reassure the Parole Commission that we've got a plan for where the client might live, what kind of work the client might do, who might be helpful to them in the transition. There are programs in many communities that are designed to help long-term inmates transition back into the communities. Ours in Baltimore is called Marion House. It's a fantastic program. And for many of our clients, just being able to say, my plan is to go into Marion House, gives them a bit of credibility with the Parole Commission that maybe they didn't have before. And so being thoughtful about the reentry plan, helping your client to think through that is really important, and then making sure that it's a prominent part of your parole packet as well. Letters of support. We collect dozens of letters of support from every possible source that we can find. So obviously you go to family, and it's great for family to be able to write letters not only about their interactions with this person and their observations of what's changed for this person over the time that they've been incarcerated, but also about the support that family members are willing to offer upon release. I can give a place to live. I can give financial support. I can give access to a faith community. I can give access to employment. Having family members who will attest to things like that is crucial for the Parole Commission because, again, their concern is how is this person going to function when they're released into the community. Friends can serve a similar function, particularly if those friends have access to employment or other kinds of resources that they're willing to offer the client. Often we get letters from other inmates, and that may seem a little odd at first glance because you're thinking, well, these are other people who are in jail. What's their credibility with the Parole Commission? But those letters are frequently very touching, and oftentimes for our clients, they will say things like, this is someone who, when I got to jail, I was a mess, I wasn't adjusted, I didn't know what to expect, and this person took me under her wing, and she helped me to understand the system, and she helped me to get adjusted, and she got me involved in this programming, and I think she's going to be an amazing support system for other folks. Similarly, we kind of counterintuitively maybe can sometimes get letters from correctional staff, though as I mentioned in Maryland, that policy for us has recently changed. But how great to have a letter from the warden or from the assistant warden that says, this person is a model inmate. We've never had a moment of trouble with them. They are a shining star in our community. They set a great example for other people. This is our success story. And for the Parole Commission to hear that from correction staff, I think is a very powerful kind of thing. So really, you're reaching out to anyone who can be supportive. And we do this within, again, a framework that helps our letter writers to understand what it is we're looking for. So we provide guidance to the folks who are going to write letters. We talk to our clients. We say, who is it that you think could write letters for you? Then we reach out to those folks and provide them with some guidance to say, here's what the letter should do. The letter should stress support you can offer, how this person has changed, what are their positive attributes, what are the great things about them. And here's what your letter should not do. It should not relitigate the case. And Lila talked about this last time. Parole is not the opportunity to do that. You're going to see it again on the next slide because it's that important. Parole is not our opportunity to relitigate, but many family and friends particularly still feel pretty upset about the ways in which the justice system treated their friend or their relative, about the outcome of the case, about the failure to consider certain things. And those things in letters are just not terribly helpful. And so we kind of negotiate what the letters look like with family and friends to make sure that we're not doing anything that's counterproductive to the client's case. So sometimes you'll see a letter that says, that judge was an idiot, and they should have understood that my sister was experiencing intimate partner violence, and they didn't, and that's why she's in jail. That's not a helpful letter. So we want to go back and help them edit and really help to educate them about what it is that we need. Finally, we will include photographs of the client and of her family, and those photographs can range through a lot of things. So in cases involving intimate partner violence, where you're establishing that that violence was part of the context for the crime, you may include photographs that were taken by police or by others that show the battering that a client experienced. But we also include photographs of folks with their families, with their kids, again, to humanize them and give the Parole Commission a sense of this person as a mom, as a grandmother, as a sister, as someone who can be part of an extended network that will provide her with support upon her release. So again, and we just say it over and over again because it's that important. You're not relitigating the case. If your client is remorseful, you want to find ways to express that remorse. And now is a good time to talk about remorse again. Not every client can express the kind of uncomplicated, full remorse that you see in the narratives of Client 1 and Client 2 that we gave you. There are lots of reasons for that. So sometimes people are tied to, and not for bad reasons, I was thinking of a better way to explain this. People see what happened as an accident, a tragic accident, a horrible accident, but an accident nonetheless. And it can be very difficult for our clients to say that they take full responsibility for their crimes when they don't see what happened as a crime. They see it as an accident. So one example, we worked a little bit, more than a little bit, on a case where the client was engaged in a fight with her boyfriend, and they both were struggling over a knife. And the next thing she knew, she woke up having been stabbed multiple times in our shock trauma unit, but he was dead. And for her, that was not a premeditated crime. It was not anything she intended to do. It was a horrible, horrible accident that grew out of an incident between the two of them, but she didn't see it as a criminal act. And so to express remorse for it was very difficult because she didn't see herself as criminally responsible. In other cases, we still have clients who are making claims of actual innocence even as they're seeking parole. And that's probably the most cognitively dissonant kind of position for someone to take, which is, I'm really, really sorry for the thing that I didn't do. So in those cases where someone is still expressing innocence, we have to find something for which our client can express remorse. And sometimes it's just, I'm really sorry that this happened, or I'm really sorry that this person was hurt or killed, whatever that looked like. Those may not be the most compelling claims for parole commissions. They may get people's raise some eyebrows in terms of whether the person is genuinely expressing remorse or not, but we have to work with the story that we have. And that particularly is a problem when post-conviction motions and hearings and pleadings are still ongoing and someone is seeking parole. So if you are making a claim in a post-conviction proceeding of actual innocence, of the state's failure to prove the case, of ineffective assistance of counsel, you may be working at odds with a parole packet that says, I'm so remorseful for what I did. And so again, we find ways to kind of skirt the two. I'm so sorry that this person died, and for any part in it that I may have had inadvertently, I am really, really sorry. He didn't deserve that to have that happen to him. While at the same time, the post-conviction is saying, you never really proved your case against this person. It's particularly an issue with felony murder cases where somebody may not have been the person to actually commit the crime, but somehow was involved in it in some way, and finding a way to talk about that can be difficult. The parole packet is also not the place to make claims of actual innocence. Again, if you can find something to be remorseful about, even while you contend that you are innocent, that's great, but it's not the place to say, I didn't do this, but I'm really sorry that it happened, and that's the distinction I would draw there. Sources of information for the parole packet. We practice a kind of lawyering called client-centered lawyering. I know this is going to sound like a digression, but I promise it isn't. And the idea behind client-centered lawyering is that lawyers and clients work together to achieve the client's goals. And client-centered lawyering is a great way to work with your parole clients because you really need them as a partner. And that's absolutely true in terms of seeking out information for your parole packet. Most of the information that you're going to get about the client's activities, leads on letters of recommendation, things for the reentry plan, the client's letter of remorse, information from the client's narrative, all of that is going to come from the client. So my students are in the prison until we recently got yelled at every week, talking to their clients, getting information from the clients, working with the clients to put the parole packet together. But besides the client, there are a number of other sources of information that you might seek out. We often contact former attorneys and other professionals who have worked with our clients. They have tons of information, particularly if they are the attorneys from the trial court level or the appellate court level, really. At the trial court level, you may have old letters of support. You may have exhibits that might come in handy. You may have just access to information about how the trial happened and what was said. At the appellate court level, transcripts. It's unbelievably helpful to have the transcripts because the state has an idea of what happened in the case, but we don't always. And to be able to counter the state's narrative or to pick out things in the transcript that really bolster the claims that you're making in the parole packet is super, super helpful. But transcripts are really expensive, and we don't have the litigation budget to go get the transcripts. So getting them from the appellate lawyer can save you a ton of money and provide you with just a treasure trove of information. Professional evaluations that may have been done either for the trial court or for post-conviction motions, like motions to modify. So you may have a mitigation report that was done on behalf of a client. There may be a psychological evaluation that was done on behalf of a client. And having all of that information is very, very helpful. The other thing that particularly a trial attorney can give you is some insight into how the victim's family might respond to the request for parole. Most of the attorneys that we talk to have pretty decent ideas, given that they were there for things like victim impact statements or the testimony of the family, as to who we should bother to talk to, who we shouldn't even bother to try with, and what the possibility is that those folks will come forward in parole hearings, as Lila described to you the last time, to argue against giving parole to your client. The more that we can anticipate those arguments in advance, the better a job we can do in terms of our advocacy in the parole packet. Institutional records are things that you might actually have better access to than your client. So for example, our clients can't get access to their parole files until very close to the hearing, and they can't make copies of anything in them. But we can get access to the files, take copious notes, sometimes if we're really, really nice, get somebody to allow us to make a copy of something. We can get access to the institutional records in ways that the client can't. Similarly, we can help our clients get access to medical records and other kinds of files that are within the prison system that may come in handy or helpful in terms of the parole hearing. Finally, again, talking to family and friends is a great source of information, but there's a caveat there, and it's this. People's relationships with families and friends when they are incarcerated get very, very complicated, as many of you know. And some of the folks that you talk to will have their own agendas. So for example, we recently got a letter from a client's close relative, and we thought that the letter would be fairly uncomplicated. This is our client's best friend as well as a close relative, but that person has a beef with the client's mother. And that played out in the letter that we got from her, and it played out in the conversations that we have with her. Well, that matters to us because the client's transition plan or reentry plan is to go live with her mother. And so it's complicated. When we're getting information from one family member, they may have issues with another family member that colors the information that they give you. Friends may hold old grudges. In gender violence cases particularly, friends may be very judgmental about your client's failure, and I'm putting that in air quotes so you can't see it, to leave the relationship, especially if the person told the client that this was going to happen and told the client so. And the client may not have a completely clear vision of what that family member or friend's reaction is going to be, because their interaction since the client has been incarcerated may have been curtailed, or because that person's never been asked for their opinion on any of this stuff before. So it's important to remember, as you're seeking information, that different folks have different agendas. Some things you need to take with a grain of salt. And some things you'll have to run by the client and say, do you think this is really helpful to you, or is this somebody we should just kind of omit? And that can be really hard for the client and really painful when somebody who they thought was an unqualified supporter maybe has something else going on. The client narrative, I think, is arguably the most important part of the packet of what we do, and that's that life story that I referred to earlier. So lawyers and advocates, our job is to be storytellers. It's the most basic thing that we do. And in the context of parole, we're really telling a redemption story, right? And it's the 3 R's. Responsibility, remorse, rehabilitation, as Andrea Bible said. It's a redemption story. As lawyers, we talk a lot about case theory, the kind of this idea of an overarching narrative or a theme of a case. And our case theories for these packets as a whole are generally pretty similar. The client committed some terrible crime. The client is remorseful. The client has changed. And the Parole Commission hears that story over and over and over again people wouldn't be doing a very good job advocating for themselves if they didn't. But what that means is that you have to make sure that your story stands out. And one way to do that is to think about what makes for a good story. So when I do classes for my law students, we talk about the basics of storytelling. What are the elements of a story? Things like characters. Who are the important characters in this story? Certainly your client, but absolutely the victim, and you have to think really carefully about how you're going to portray that victim in the course of the narrative, right? Particularly if the victim was an abusive partner, and the story is pretty complicated in that way. We have to be realistic about the fact that our clients are the ones who are in jail. So we can't paint them as kind of angelic, and most stories are more complicated than that anyway. But we want to be careful and think critically about how we present the characters. Similarly, how do we present the context of the story? Again, when we're talking about intimate partner violence, that context is going to look very different than, say, a story that involves a stranger crime. And so some of our clients, I should say, because we're a gender violence clinic, everybody who we represent has had some experience of gender violence, but that's not necessarily what brought them to prison. Nonetheless, that's an important part of their story. It's an important part of the context. Some of our clients are in the situations that they're in because of gender violence. When you've experienced child sexual abuse in your home and you try to tell your mother about it and she puts you out of the house at a very young age and you find yourself living with a bunch of kids on the streets, right, that's the context for the crime, and it's important that we explain that to the parole board. Most stories have a problem in them, right? So there's a steady state, things are going along, life is what it is, and then there's this problem that intervenes. And we try to be really careful about how we define that problem. So sometimes in an intimate partner violence murder case, that problem is the struggle over the knife that I described to you, or the imminence of another assault coming and taking action to prevent that from happening. And sometimes the problem is I was using drugs and I didn't know what I was doing that night. And then we always try to provide the parole board with a solution, that in this story, because we have this rehabilitation, the solution is you let this person out and they're going to be a productive member of society. We also talk a lot about what makes a story compelling. So details, and really getting into the details of the client's life so that the parole commission has a rich understanding of that person matters a lot. Developing your characters matters a lot. Giving the parole board a time context, a place context. Things look different when they happen in some neighborhoods than when they happen in other neighborhoods, and it makes the story more understandable for the parole commission. And finally, we've got to address the weaknesses in our case. So for some of our clients, many of our clients were abusing alcohol or controlled substances before they went to prison. Why are they not going to do that again? That's a weakness in our case. What's going to prevent them from relapsing? We need to be sure that we're talking about that and giving the parole commission some confidence that it's not going to happen again. The fact that someone comes from an unstable family may be a weakness. Lila knows this one better than I do, but there was a client, not of ours, but a woman who was incarcerated who was denied parole because she didn't have family to live with and strong family ties after she left. I would never have guessed, given that she had a reentry plan that included transitional housing and all kinds of other things, that that would be a weakness in her case, but it was, and so that's the kind of thing we need to think about. The history of intimate partner violence can be a huge weakness in our case, particularly given the kind of stereotype that says that women who've been subjected to abuse go from abuser to abuser. If you were in an intimate relationship that was tied to the crime in some way and you're asking us to let you out, you better tell us why you're not likely to become involved in another such relationship in the future. Mental illness can be a weakness in our cases. If you were suffering from depression or bipolar disorder or some other kind of mental illness that contributed to the commission of the crime in some way, you need to let the parole commission know why that's not going to lead you to the same place again. And so we're clear about the weaknesses in our case, and we try to deal with them head on, because we don't want to put the client in a situation where the first time they're being asked to talk about that or think about that is in the context of the parole hearing itself. Again, for those of you who can advocate within those hearings, you can take those questions. But for those of us who can't, We've got to anticipate them ahead of time and try to head them off, in part so that the Parole Commission has a better sense of the client's case, but equally importantly so they don't ask those questions in the hearing. Those are the kinds of questions that can really cause our clients to get flustered or upset, and in an already stressful situation can lead to answers that are unsatisfying to the Parole Commission and may lead to the denial of parole. So we're trying to deal with all of the problems in our case, and again, problems in air quotes. Some of those things should not be problems, but they are. We're trying to deal with all of the problems in our case right up front so that we don't have those kinds of issues. All right, so now we're kind of to the meat of really the reason that Sue is putting on this webinar in some ways, which is about when your client's narrative is a narrative of gender violence. So those of you who are on this call certainly know that the vast majority of women in prison have experienced some form of gender violence. There is no reason to believe that clients who are seeking parole would be any different. Gender violence can come up in lots of different ways and in lots of different forms. So we may have clients who've experienced rape or sexual assault, intimate partner violence, and I should have put trafficking on the slide and I didn't, or trafficking. Gender violence can be part of the crime, where you have killed an abusive partner or hurt an abusive partner, or where you were acting under duress at the behest of an abusive partner. But even if gender violence isn't specifically part of the crime, it may have had some impact on the client's development of life skills, on the client's ability to secure an education, on the client's work history, or on the client's mental health, in ways that it makes it important for us to explain that context to the Parole Commission. So we talk about both gender violence related specifically to the crime for which the client is incarcerated, and about past trauma that has occurred in the client's lives. So if you look at the narrative of client 2, before we get to the point at which she's struggling for a gun with her abusive husband, she's been sexually assaulted, she's experienced a tremendous amount of trauma, and all of that contributes to her being in the relationship that she's in and being on the other side of that gun. We think that it's really important for the Parole Commission to understand how our clients get to where they are, and gender violence is a crucial part of that narrative. The problem that we sometimes have is, particularly in those cases where gender violence was part of the crime, a judge or a jury has pretty much dismissed the claim of abuse, and sometimes with extreme prejudice. In one of my least favorite cases, and it's actually the case of client 2, one of the leading experts in the country testified on behalf of our client as to the gender violence that she had experienced after having been retained by the state, which had asked her to say that our client was not experiencing domestic violence. So she's retained by the state, she examines the client, and she finds that not only is the state wrong, but that our client had been suffering from severe violence and that she had all of the kind of symptoms and sequelae that go along with that. And the judge basically said, yeah, no, I don't believe that. I don't believe her, and I don't believe you. And that's a problem because the Parole Commission has access to those findings and those records. But where abuse is central to the client's narrative, we have to take that problem on head on. And so we include that information and we stress the reasons why our client's story is credible, which is different than saying that the judge or the jury was wrong. In those cases, we pretty much ignore what the judge or the jury has said, or say, notwithstanding the fact that the court found X, here's all the reasons why you should find her to be credible. And so you have to remember that we're dealing with a different standard, right? We're not trying to prove self-defense. We're not trying to invoke battered woman syndrome as a defense. We're not trying to do anything more than to explain how the client found herself in a situation that led to the crime at issue and why she won't find herself there again. And so you've got to make that persuasive case about the client's experiences. You can do that based on the client's testimony or narrative. You can do that with photographs. You can do that with medical records. You can do that with witness statements, with expert witness opinions, with documentation from service agencies that have worked with the client, the letters of friends and relatives. anything that you can get your hands on that bolsters that claim is going to be useful to you in terms of the parole packet. And you want to check the corrections records, because in some of these cases, even though a judge or a jury said, we don't believe that you've experienced intimate partner violence, the prison system may have said, oh yeah, you're a victim of intimate partner violence. Let's make sure that you get the programming that you need. So again, in Client 2's case, she got all kinds of services for having been a survivor of gender violence, even though the judge and the jury had said, we don't believe these claims. The judge, I'm sorry, had said, we don't believe these claims. In her case, the prison treated her as someone who'd been subjected to abuse from the beginning of her incarceration. And we've had several clients who look the same way. So we were able to allude to her participation in these kinds of groups as part of our reason why she won't recidivate. In cases where the client has killed her abuser, like everybody else in society, the parole board is likely to ask, why didn't you leave? And as unfair as that question is, we need to have an answer for why that person didn't leave. And that can often be really difficult for clients. It puts them back in a place that they don't necessarily want to think about. So to write these narratives requires them to relive trauma that they may not have been able to access for quite a while, that they may be repressing in some way. You know, I know that most of you know this, but it always strikes me how hard it is to live in a prison environment, and how much kind of tamping down of one's history, of one's emotions, of lots of things that one has to do just to be able to survive day to day. And what we do when we go into the prison is basically ask people to dredge up the worst experiences of their lives so that we can better understand them and represent them before the Parole Commission. That is a really, really hard thing for clients to do. There better be a good reason for it. And the reason is because we have to explain to the Parole Commission why it is that they were in that situation and why they won't get involved in other abusive relationships. So know that kind of crafting these narratives can take a tremendous amount of time. Clients may not be willing to go to those places readily. It might take them some time to really grapple with and process the trauma that they've experienced. And also know that we're asking them to do that without any guarantee that there is someone who is in the prison system with whom they can process. So many of our clients are getting services. They're involved in groups for women subjected to abuse, or they're getting therapy of some kind, but some of them aren't. And so dredging all this stuff up and just leaving people is a really hard thing to do. So be attentive to the client's willingness to engage in the conversation. Know that you have to move at their speed, not yours. Understand that you may not get the full story, but that you have to do the best with what you get. And always remember that the bottom line on these client narratives of gender violence is that there's a really fine line that we're walking in these narratives, that the intimate partner violence or other form of gender violence is not an excuse for the crime that was committed. It's a context for understanding why this person did what she did, reacted how she did in that moment that led her to be where she is. I would just say as an aside, you know, the other thing that I've noticed from having done these cases is that most of our clients tell stories where if they had done one thing differently in that one split second, everything's different. And I know that sounds kind of intuitive or possibly stupid, but it's hard to explain that in a narrative. And so you really have to help people understand how they get to that one moment where everything changes and how gender violence contributes to that. The other narrative that can be really hard to tell is the narrative of mental health and gender violence. Many of our clients experience mental health issues in addition to or as a result of the gender violence that they experienced. And some of that, as with Client 2, is not diagnosed until their incarceration. The Parole Commission may misread something that a client says or does because they're unaware of the mental health issues that the client is experiencing, or they may be concerned that untreated mental health issues make the client too risky a prospect for parole. So we want to try to anticipate any concerns that the Parole Commission might have about someone's mental health and address them up front. So as you can see in her letter of remorse, Client 2 talks a lot about how her mental health issues contributed to the issues in her relationship with her husband. She talks about the treatment that she received both in and outside of prison. She talks about the medications that she's taking, and she talks about the plan for managing her mental health upon release. You'll also note that she talks about the side effects of that medication. This was one of Lila's clients, and Lila should certainly feel free to jump in, but the client has really notable tics as a result of the medication that she takes, and it causes her to, as she says, move her fingers and tap her feet. This is not a subtle thing. It's very, very noticeable, and when you sit and talk with her for any period of time, you see her doing it. And we knew that she would be doing those things during her hearing, and we wanted to give the Parole Commission some context for understanding why that was, rather than having the Parole Commission misread it as evasion or as nervousness, or as indicating that she was concealing anything in some way. And so we try to be, to the extent that the client is comfortable with it, as upfront as we possibly can about how people self-medicate, how people experience depression, how that contributes to the context for the crime, the treatment, and then we try to also be clear about the treatment plan that the client's going to follow, that they'll continue therapy, that they'll continue taking whatever medication that they're taking, to make sure that the Parole Commission understands that the client takes the condition seriously, understands that it may be a barrier to release for some reason, and is taking steps to take care of it. After I did this slide and as I was preparing today, I realized that many of the same things, like you could substitute substance abuse and gender violence for mental health and gender violence and have almost the same conversation. So many of the same things are true about substance abuse. We need to talk about how the substance abuse was triggered or exacerbated by gender violence, how substance abuse was related to the commission of the crime. Many of our clients are self-medicating because of past trauma and gender violence, and we need to talk about the reasons why our clients turn to drugs in the first place. Many of our clients get sober while they're incarcerated. We want to celebrate that, and we want to make it clear that they have long periods of sobriety in unbelievably stressful conditions. So it's easy, I think, for the Parole Commission to say, well, you're sober in prison where you can't get access to anything. If you happen to be in Maryland, you know that that's not true, that our prisoners get access to drugs all the time, and the temptation is there, or can get access. But that they've stayed sober under unbelievably trying conditions, that they'll be able to do it under the difficult conditions upon release when the stress of the world is kind of imposed upon them, and what the plan the client's going to have to deal with their substance abuse issues upon release. One of the concerns that comes up from time to time is that the client wants to move back with family, and that family has substance abuse or mental health issues, and that's something you really need to think about in terms of the reentry plan. So preparing the client for the parole hearing. The first thing we have to do is kind of help our clients think through how they're going to deal with both their nerves and their expectations about the hearing. So a parole hearing is public speaking. It's public speaking about the worst thing that you ever did. It's public speaking potentially in front of the people who you hurt the most as a result of your crime. And it's public speaking upon which your chance to be released from prison hinges. It's hard to think of a more stressful situation that we could put somebody in than a parole hearing. It also requires people to delve back into their feelings around the crime, and as I've said already, asking people to relive the most difficult parts of their lives is not an easy thing to do, and that trauma that people may not have been able to fully process can be really difficult to deal with. The parole hearing can bring all of that up. In addition, some of our clients have really unrealistic expectations about the parole process. So when I say that, I mean this. They know that many of their friends have gone up for parole and have done what we call taking a hit last time, have been given an additional time before which they can seek parole. They know that few people who've committed crimes as serious as their crimes are let out at the first parole hearing. And yet it is very, very, very difficult for them not to hope that they might be the one who gets out. So we don't want to discourage people. We want them to be actively engaged in the parole process, and we want to get them out. But we also know that it's unlikely that someone who's been convicted of murder is getting out at their first parole hearing, that people are likely to take that hit for additional time. And we have to help people have realistic expectations about what the hearing is. Talking about gender violence, I'm going to say it again. You're sick of me saying it, I know. But again, we help clients to understand this is not an excuse. This is context. And that can be hard for the client to understand. The client may be angry still about the outcome of the trial. The client may still be angry about a judge or a jury's failure to recognize that they were a victim of some form of gender violence. And some of our clients, even though they accept full responsibility for their crimes and they're absolutely remorseful, are still ticked off about the way that the trial went. Even clients who say, yes, I'm guilty, are still ticked off about the way that the trial went. So we have to help them think through how they want to talk about their crime and the role of gender violence in their crimes, understanding that this is instrumental, right? The goal of this hearing for us is to help get clients out of jail. So we have to help them figure out what the best way is to do that. Expressing remorse, we've talked about that. I don't think I need to say anything else except that it's important. They got to figure out what works for them. Handling difficult questions, our clients have gotten crazy questions that they can't possibly answer. They get questions like, why did the state's attorney charge you with second-degree murder and not manslaughter? They are asked, why didn't the judge believe your claim of domestic violence? One of our clients during a parole hearing was asked about what sex with her husband was like, which threw her off entirely. So our clients are going to get difficult questions. They're going to get difficult commissioners. You know, our commissioners range from people who absolutely believe in the possibility of rehabilitation to people who absolutely think that there's no criminal who should ever get out of jail ever, and everything in between. And the luck of the draw really determines who it is that you're talking to on that day. So we have to have our client prepared to deal with the most difficult issues that may come up, right? And so we do that by mooting. We moot and we moot and we moot some more. We practice with clients the hearing. We ask them every question that we can think of, the hardest questions and the easiest questions, and we do it over and over again until clients are comfortable with the answers that they want to give. And then we bring in people who are strange to them if we can. So in the law clinic setting, my students are really the ones working with the clients. So Lila, for one of our clients, mooted her 5 times before I ever came in as the strange judge to come ask hard questions. And I'll do that frequently with our clients so that they get somebody different. So when they're used to Lila and they feel settled and they can answer those questions pretty easily, then they get me and they have to really think about their answers again. And I tend to be a really mean parole commissioner so that we can get them ready for the worst thing that can happen. So I want to help the clients get out of jail, right? That's my goal. And we have to figure out what story it is that the client feels comfortable telling in that context, and then we have to help the client tell it as best we can. And going back to the idea of client-centered counseling, that's a really important thing here. If the client's not comfortable with the story, the client is not going to be able to tell that story well. The client is the one who has to sell this at the hearing, not us. So the client has to be comfortable with the way it's explained. So coming up with answers is a collaborative process where we really talk through, how do you feel about remorse? What can you tell us about your experience of domestic violence? What can you tell us about your relationships with your family? And those things can be really complicated, and we try to help the client work through what the best answers for them are. And at the end of the day, for us anyway, our client is sitting alone in that hearing room. They're not allowed to have any advocate with them, and in all cases, they're forbidden from turning around and looking at who might be supportive in the audience. In some cases, they're forbidden from even looking at anything. We've had people who've been shielded off so that they can't even look around. So it's all on them. We've got to make sure that they're as prepared as humanly possible because they're sitting in that room by themselves.
Leigh, before we move on, one thing that I would just add is you're not only preparing the client, but through the parole packet, you're also preparing the commissioners. When we think about gender violence, there are a lot of stereotypes about what a victim of gender violence might look like. And sometimes our clients don't fit that stereotype, so it may be very difficult for a parole commissioner sitting across from one of the clients to imagine that this woman in front of me, who is now confident and assertive in the way she tells her story, could have ever been a victim of serious abuse. And so that can be a problem for credibility because a commissioner is buying into these stereotypes. So that's part of our job to address in the packet, in the narrative, to say, this is the way I was at this point in my life when this was happening, and this is how I've changed, so that who you see today is not who that person was. It's just as important to prepare your client as it is in the packet to signal that shift for the parole commissioner.
That's a great point, Lila. Thank you. You know, the other piece of that, too, in terms of stereotypes about who victims of violence are, oftentimes our clients fight back against their abusers. And as those of you who do this work regularly know, people who fight back are not seen as victims in the same way. And so if that's part of the narrative, you know, we've got to be able to tell that story. Because if you're fighting back, then you're not passive and weak, then you're not a stereotypical victim of intimate partner violence. All right, so beyond the parole packet, other advocacy that you can do. Before the hearing, information gathering, and that's, again, both for the packet, but also just to prepare the client for what's coming. So we're looking at prison files, we're looking at parole commission files, we're trying to find information about the crime and the trial and the sentencing, we're trying to find letters of support, everything that we can come up with. We're trying to engage families in the process wherever we can, but that brings with it a number of issues, right? So I talked about managing expectations for folks who are incarcerated. In some ways, it's almost as difficult to manage expectations for family members who aren't interacting with other folks who've gone before the parole commission on a daily basis and don't have a sense of kind of how rare and how wonderful it is for someone to be granted parole, at least in our system. And so we have to be clear with the family. We're likely to take a hit, and if we do, we're going to do it again, but we've got to start somewhere, and this is where we're going to start. Or they may not get out immediately. Sometimes, as Lila said last time, we get a delayed release. So the family is thinking, you know, they're going to be home tomorrow when in fact it's going to be 2 years from now. Sometimes it's about the amount of time that the parole commissioner is actually willing to spend. So you'll see that we have pre-hearing meetings there. And oftentimes you may have the opportunity to meet with a parole commissioner before the hearing, but they're only going to give you the half hour that you've been allotted, not all day, to talk about your family member. Family members have to refrain from relitigating their claims. They have to deal with all those old family issues. But if you can get the family to attend those pre-hearing meetings with commissioners, or where it's permitted, the hearing itself, I think it's absolutely invaluable for the parole commission to hear from people who have a relationship, who are willing to lend support, who can make concrete promises about what they will do, and who can really humanize your client for the parole commission in the way that, you know, despite our best efforts, the packet just can't do. As I said, we often have pre-hearing meetings. The packet is a great thing, but we never give up an opportunity to be persuasive in person. In Maryland, we're able to meet with one commissioner prior to the hearing. That commissioner's notes end up in the file. The family gets an opportunity to meet with the commissioner and put a face on the support that they can provide. And we can make sure that we direct the parole commissioner to whatever parts of the packet we think are most important, and hopefully that will go to whoever actually finally hears the case. So for us, it's a random parole commissioner for the pre-hearing meeting. That may or may not be a commissioner who ends up in our client's parole hearing. Sometimes we hope it is, sometimes we hope it isn't. The pre-hearing meeting also gives you a chance to test some of your theories and see how they fly. So, you know, if we're telling a narrative of gender violence, we want to see how that works with the commissioner. We want to hear what the commissioner's concerns about the case might be. If the commissioner tells us, well, this reentry plan, it looks a little bit thin, then we're working to beef that up so that the client has a stronger answer. If the commissioner says, oh my gosh, this is a really sympathetic story, then we know that we want to tell that story. And so that's a very helpful thing for us in terms of the mooting process, to give our client a good sense of what the commissioner's concerns might be. And again, we help people to develop their reentry plans. So we're often in touch with Marion House on behalf of our clients to say this client is seeking parole, they want a space when we get out. We work with family members and others to try to figure out what that's going to look like. And that all happens before the hearing so that we can present that information at the hearing. in terms of after the hearing, you may be doing follow-up with the Parole Commission. You may be doing follow-up with the governor. So for us, when a lifer is given parole by the Parole Commission, it still has to be signed off on by the governor. So we need to do advocacy with the governor, too, to make sure that those files don't sit on the governor's desk forever and that the governor approves some of those files that have come through the Parole Commission. We also might or might not do media engagement, and there are some real pros and cons of working with the media. You know, the pros are if you get a client's story out there and you can build political and community support for paroling someone, that is a wonderful thing. You know, the more pressure that's being brought to bear on the system, the better. But you have to make sure that all of that pressure is going to be positive. And so we recently had an interesting experience with a client who's very involved with yoga in the prison system. And a publication did an article about that program, and it quoted her about several different things. But one of the things it said is something that really doesn't help our case very much. And so, you know, having put that out in the media, we had this real difficult conversation with her about, you know, this is great and it's wonderful exposure for the work that you're doing, but I don't think we necessarily want to put this piece of it in front of the Parole Commission because we don't want them thinking about this one thing. And the client was really upset because she had said more than she intended to say. Clients don't often have media training. They sometimes say things that they don't want necessarily to get out into the world. They don't, you know, either they're comfortable with the reporters and saying things that they don't expect to be made public, or they just don't think about it until later. And so while media engagement has the potential to bring really good pressure to bear on decision makers, it can also come back to bite clients. You definitely want to have a conversation with folks before they make a decision to engage in any kind of media attention. The other thing is institutionally, media attention can have ramifications both among corrections officers and among other inmates. And so there are repercussions to that, right? So you have somebody with no I'm making up, this is a hypo, but you have somebody who has no institutional history of bad behavior, but people are jealous of the fact that they've gotten all this media attention and maybe start to pick at that person and try to undermine them in some way. I think bad things can happen, so it's worth having a conversation with your client about whether they really want to be involved. Dateline did a story a couple of years ago now on the prison system in Maryland, and it's been really interesting to kind of see how that's played out for our clients who were part of that story. And Lila, you may have a comment about that.
Yeah, I would just say, I would just echo Leigh's remarks. It was 60 Minutes, Diane Sawyer did the piece.
Oh, sorry about that.
Yeah, and for the clients who were featured, you know, there's a lot of politics that go on behind selection to participate in this kind of thing. And I would say the net effect was that it made her life a little bit harder within the institution. And also it came back to bite her at her parole hearing because the victim's family members were very angry that she had been featured on a national news story and thought that, you know, it showed total disregard for their pain and suffering, and came to the parole hearing and spoke very strongly about that. So it's really a difficult line to walk.
So I think, thanks Lila. We are at the end of our slides, and I think, Sue, I've given us 17 minutes for questions, so I'm happy to open it up to questions now.
Well, before we do that, I'm going to take the last 2 minutes, because one thing I wanted to mention is that Leigh gave a lot of really helpful information about how to put this packet together and what you need to include. And from a practical standpoint, I want everyone to understand, especially if you've never done this, that sometimes these packets can get really lengthy, particularly when you think about collecting certificates or program completions within the institutions. So a lot of time my students are saying, well, can't I leave the certificates out? You know, they're never going to read 75 pages about this client. And I think that that's probably right. Parole commissioners are not going to look at 75 pages. But that doesn't mean that we don't include all of those certificates. And so when you're putting together these packets, you have to be really strategic about organization. And what I like to tell my students is with every page a parole commissioner turns, you have to assume that they're a little less likely to turn to the next page. So Leigh talked about how valuable letters from supporters can be. They're so valuable, but you have to assume that the parole commissioner is not going to read all of those letters. So what we'll do is we'll take the strongest letters and put them sort of closer to the front of the packet, but we also quote from those letters in things like the legal memo. So if somebody is not going to read the entire letter from a client's sister, what was the most impactful thing that was said in that letter? And then we use it under a heading where we're talking about what great community support that person has. And you'll see that in examples that we've posted of the legal memos. And then it's also as simple as doing things like indexing. Do I think that a parole commissioner is going to look at all 40 certificates that this client has amassed? Absolutely not. But if I have a table of contents in the front of the packet that sort of lists every single program by date that they're going to find in terms of certificate, they don't need to flip through them. They can look at the table of contents and see that content right up front. So I know that it's something that sounds simple, but I think it really does make a big difference. So that you can sort of focus on the front of the packet, what do you really need to get out, and what are some ways you can be strategic in conveying information.
Yeah, the other kind of funky graphic design thing that you can do is to do pull quotes and just have a page of pull quotes. So like all the best quotes from various things and just use that as the front of one of your sections. All right, Sue, now I think we're good for questions.
Okay. Wow, that was incredibly helpful. Thank you, Lila, for chiming in there, because one of the questions I did have was how long do these packets tend to be, and is there such a thing as too long? And I think you did a really great idea. I gave a great answer of giving ideas on how to organize them in such ways that the information is available, but you can really pull out the important stuff. So that was really helpful. So thank you. Leigh, I had a question for you, which was just in the very beginning, you started talking about, we need to address some of the weaknesses in the case. And some of it's about language. Now, when you're talking about the case, were you talking about like the parole case?
Yes.
Are you talking about, okay, so that just was, okay.
Yeah, sorry about that. I'm talking about, when I'm thinking about the case, I'm thinking about our parole packet as a case.
Okay, that's really helpful. So it's not addressing the weaknesses in the original trial.
We are not relitigating.
That over and over, but that was just a little confusing about the language. So
sorry about that.
No problem at all. Actually, my coworker Dot had a couple questions, and one of them was really thinking about that issue of working with people who have been incarcerated for a very long period of time, which you said are many of the people that you're working with. And a question is, how do you work around some people who do not have that family support or may have lost the family support after years and years in prison? And that was a distressing story, hearing about the woman who had a really good reentry plan, but it didn't include family.
Yeah, I'd like to think that's an anomaly,
Okay.
And it was like a bad commissioner on a bad day. And I think that the best thing that you can do in that situation is knowing that you're not sending someone out to family support. The families that we create are as important as the families that we've come from. So if we can create a community around that person in some way, I think that that's the best that we can do. The other part of it is that we can talk about how toxic the family of origin is and talk about why the person is more likely not to recidivate. Sorry, I know that's a bad construction. Why the person is less likely to recidivate if they stay away from their family, and to just kind of take that piece of it head on. The best we can do is to craft strong reentry plans that really take account of the various needs that a person is going to have leaving and try to fill in all of those holes as best we can. But yeah, it's a terrible story, and I was actually pretty shocked by it.
And I'll just say that was my client. Happened a few months ago, and I was shocked by it. And I do think that it was an anomaly, and I think that we had the worst commissioner on one of his very bad days.
Okay. May he not have another bad day, huh? I also just really appreciated, Leigh, what you were talking about, really dealing with how complicated those relationships with friends and family can be. I mean, that's true for people who are not incarcerated. So, I thought that was really helpful. Another question was, do you know why the policy changed about guards writing letters?
I can speculate, but I don't know. Lila, do you know for sure?
I do not know for sure, but I also have strong speculation.
But here's my speculation, and then Lila can give hers. Right now, the Maryland correctional system is pretty much under fire for a number of inappropriate relationships that occurred within our system. Some of you may have seen the coverage of the way that basically that gangs were running Baltimore City jails, that prison guards were having babies that were fathered by male inmates. There's been a series of punitive measures since then that have been designed to both ensure that people are not fraternizing and to decrease the flow of illegal substances into our jails. And so there have been a number of bad policy proposals, among them not allowing inmates to get mail other than postcards so that contraband cannot be secreted inside of envelopes. And I have a funny feeling that this is just another one of those things to discourage prison staff from getting too close to inmates. Lila, what do you think?
I think that could be part of it. I think the other part of it is that the chairman of the Parole Commission here really takes the position that Department of Correction employees should not be advocating for inmates. That's not their role. Their role is to supervise, not to advocate in anyone's case, and that it creates sort of a conflict of interest, which is problematic from our standpoint because for someone who's been incarcerated for a very long time, it's really institutional staff who can speak to their change the best.
And at least at our women's prison, we had an absolutely wonderful warden who has really been supportive of a lot of the women that we work with, and losing the ability to say that in parole hearings is a real loss for us.
Going back to, talking to family members, friends and family in the community, and when working on the reentry plan, I'm wondering if you guys are struggling at all with the issue that so many people have been incarcerated at this point. Is that a problem that you're seeing, that people are unable to return to family if they have somebody in the family who had served time in the past?
I have not run into that yet.
Me either.
Okay, great. May that not happen.
Yeah.
May that not happen. Just a general question. I mean, what you're doing is so thorough. And I'm just wondering, how long, and I know it's going to vary from situation to situation, person to person, case to case, but how long do you tend to spend putting together each parole packet? And then also, if you could also address how long you spend on the mooting, because that sounds like that could also take a lot of time.
Yeah, so, you have to remember that I have law students doing this, and this is the first time that they've done any kind of legal work. So it takes them significantly longer to do things than it might take an advocate who develops an expertise in it. So, Lila, the first one that you did, took us the better part of, 7-8 months.
Yeah.
And then over winter break, Lila and I slammed one together for an inmate in less than a month. So it's context specific in that neither one of us can say no to people. And so if we get a client who really needs help on a short turnaround, we can get it done. It's not as thorough as we'd like it, and maybe not as polished as we'd like it, but we can get them done pretty quickly. And I think the more of them that you do, the easier it becomes to kind of know what steps to take. I think it's realistic to say that you could do a really great job in 2 to 3 months, depending upon the client's ability to be a full participant in the process. Because sometimes the process is slowed down, and this is not meant as a criticism, just as an explanation, by the client's inability to really access all of the things that have happened to them and process that trauma. And that you really have to be attentive to that. In terms of the mooting, oftentimes what happens for us is that we know what the parole date is supposed to be. And so we start building in those moots. But when the packet's done, a couple of months before the hearing is supposed to hit, we start building in the moots. I'd say a moot, Lila, what do you think, about an hour at a time?
Yeah, about an hour at a time. And even for my, most articulate clients, I never moot them less than 5 times. Because as Leigh mentioned, you really need to do it in a variety of different styles because you don't know what parole commissioner they're going to draw and what kind of day that parole commissioner is going to be having. So to start out the moot, we take it really easy. I pose kind of softball questions to sort of get them in the mode of what this is going to be like, build their confidence a bit, and then as the moots progress, they get harder. I'll bring in someone that they don't recognize, that they've never met. I'll be nasty because they occasionally will get someone who is nasty with them. So I would say that it takes about 5 moots.
Wow.
Which is not to say, but you also have to remember we work in a bit of a rarefied context in that I can have my law students go to the prison, for 5 hours. I think those are all ideals, but I also think that we shouldn't let the perfect be the enemy of the good. And people are walking into these hearings with no packet and no representation, and anything that we can do for them to get them prepared for this process is way better than having them go in completely unprepared.
That's a great line. We shouldn't let the perfect be the enemy of the good. Yes.
I stole it.
Yes. It's a good one that other people, I think, should steal or share, I guess. So Leigh, can you tell us, if you would, and if you don't want to, I understand, what happened at the prison that your students got yelled at?
Oh, gosh. They were all, the prison, what I'm told is there were so many of my students going into work with people that they were taking up all of the available space. And it was preventing other lawyers from meeting with their clients, and that was creating real problems in the prison. My students tell me that they've never seen any other lawyers when they've been there, so there's some conversation about that. But I respect the warden tremendously. I think she's done amazing, amazing things to work with the women there. And so if that's what she's articulating to me, then I want to try to help her solve that problem because she's really been a friend to this program.
Okay, that's great. And I'm sure that makes a huge difference. One last question here is, what are some tips or tricks in addition to mooting that you've been doing to help people manage the expectations or disappointments? So the most important thing I think that we can do for our clients is to be as transparent as humanly possible and to give them a sense of, and don't misunderstand me, they know. I mean, they're talking to other women in prison who are going up and it gets into the ether, right? Everybody knows what the hit has been, kind of people know that stuff. But I think we just have to be as transparent as possible to say, in our experience, if you're a murderer and you're going up the first time, you're going to take a hit. We know that. This is a process. We're building on the work that we're doing now. We're laying a foundation so that when you go back the next time, we'll be able to do a better job. We'll be able to have more of an impact. And the other thing that we do is, at least for me, the great thing about being a law professor is I'm not going anywhere. And this clinic is not going anywhere. So I can say to clients, and when you go up next time, we'll be there again, and we'll update your materials, and we'll moot you again, and we will be by your side for this process. And I think that helps people to feel less that whatever happens, we have some plan going forward.
I talk to my clients about this in really concrete terms, and I tell them, you've seen people go out for parole, you know what can happen, and what can happen if you're not prepared for this hearing is that you can receive a rehearing date that's 7 to 10 years out. And I do not want that to happen to you. Do I think that it's likely that you're going to be paroled at your first hearing? No, I have to be transparent with you, I don't. But my goal for you is to get you a rehearing within 2 to 3 years. I do not want a 7 to 10 year rehearing period. And I think that helps sort of focus them on the fact that this is going to be a multi-step, long-term process.
And then, when we get great results, client two? Client two's rehearing was for a year and a half, right, Lila?
It was for 2.5.
Two and a half. Sorry, I lost track. But for a first-time parole hearing for somebody with a murder conviction, 2.5 is almost unheard of. Yeah. So, that's a great result. And we're able to say, this is so much better than it would have been, and we'll keep working with you going forward.
Right.
Well, I'm conscious of the time, and I also just want to say that that piece that you, Leigh, talked about today and about storytelling was really helpful. And so I just wonder if there's materials that are available about that and in this particular context. So maybe we can talk some more about that later to figure out a way of sharing that with other people, because I thought that was really, really helpful, as were both of these webinars. So I really want to thank you both. Any final words? If not, it is 4:30, but is it okay if people send questions your way?
Always.
Absolutely.
Okay. And if you can share them back with us, that would be terrific, just so we can also figure out maybe what the next steps are. So it's so great you guys are doing this fabulous work, and again, thank you so much for sharing it with all of us. These were really, really powerful and informative webinars, so thank you both.
Thanks for doing it, Sue, and thanks for all the work that you guys do. It's amazing work, and we're just happy to be part of it.
All right. Thanks to all. Have a good afternoon. Thank you.